What I want to do in this video is talk about one of, if not the most important principle of the UK's constitutional framework. This is known as the doctrine of parliamentary sovereignty. Now, this lesson is going to essentially explore the doctrine of parliamentary sovereignty in English law, and we'll explain what it is, how it works, a little bit about the history of parliamentary sovereignty, and some of the perceived restrictions on the concept of parliamentary sovereignty. So, let's just begin. What is parliamentary sovereignty, the doctrine of parliamentary sovereignty? Well, it is a foundational principle of the UK Constitution, and it asserts that Parliament is the supreme legal authority in the country. More specifically, it is the supreme law-making authority in the country, the supreme legislative authority. Now, the doctrine is central to the concept of our uncodified constitutional framework, and has, of course, like with all of our constitutional principles, developed over many years. Now, there are three principles, as asserted by theoretician and constitutional scholar A.V. Dicey in the 19th century. There are three principles associated with the concept of parliamentary sovereignty. The first principle is that Parliament can make or unmake any law they choose. Parliament has the complete, unrestricted power to legislate on any matters. This includes the ability to create laws, to amend or repeal laws, no matter how significant the subject matter may be. It could be in relation to the Constitution, to human rights, to economic policies. In essence, then, Parliament is not bound by anything in terms of law-making. And this brings about a number of theoretical conceptions, which is, firstly, this idea that you could theoretically pass a law in Parliament that says that it is lawful for me to murder my next-door neighbour. There is nothing stopping Parliament from doing that. There is no higher authority when it comes to lawmaking. We don't sort of give ourselves up to a codified constitution that has the final say in making determinations on matters such as that. A logical extension of that concept, then, is the idea that Parliament can therefore not bind a future Parliament. So a Parliament cannot enact a law today, for example, that could limit the legislative freedom of a Parliament that is called in the future. This means that one Parliament cannot restrict the actions or the powers of a subsequent Parliament. One of the principles within this idea is sometimes known as the doctrine of implied repeal. What implied repeal tells us is that if a Parliament passes a law, let's say, and then a future Parliament passes a law which contradicts the previous piece of legislation, then it is said that what has been implied is that Parliament has repealed the previous piece of legislation. It is the one that's more recent that takes precedent. So they might not expressly and explicitly state we are repealing this law and passing this new law, but by simple virtue of the fact that there is a contradiction between the two pieces of legislation is enough for Parliament to have implied that they have repealed the previous piece of legislation. That is known as the doctrine of implied repeal. The final principle of parliamentary sovereignty is that no court can question the validity of an act of Parliament. Courts, through the judicial review process, can spend as much time as they like thinking about and restricting the actions of the government, of the executive branch, and of the and through the process of administrative law and the administrative institutions. But courts in the UK do not have the power to overturn or to invalidate laws that are passed by Parliament. This is a distinctive feature of the UK's common law system, where judicial review does not extend to acts of Parliament. Judicial review only extends to acts of administrative institutions, i.e. branches of the executive, the parts of the executive branch of government. In terms of its historical development, we have ourselves a timeline right here. The roots of parliamentary sovereignty can be traced back to the 1688 Glorious Revolution. Without going into too much detail as to what happened here, essentially we see the overthrowing of the Catholic monarch of James II in favour of William of Orange. Now, this came after a particularly tumultuous period of history on these isles, which included a revolution and a number of civil wars, as well as the establishment of a republic and the restoration of a monarchy under Charles II. Now, if you want to know more about this particular period, not only the Glorious Revolution, but then the subsequent Bill of Rights, I have a series of videos on A-level history on the topic of Stuart Britain. So if you're somebody who is studying that module, then you will be very happy, hopefully, about the fact that there's a playlist on that already. Or if you're somebody who is just generally curious about this particular period of history and wishes to enlighten yourself a little bit more, then head over and find that playlist on the channel. But ultimately, the Glorious Revolution of 1688 and the subsequent Bill of Rights of 1689 limited the powers of the monarchy and established the principle of parliamentary supremacy. We then get some of the theoretical foundations of this particular principle with the modern works of the 19th century, particularly the work of A.V. Dicey's Introduction to the Study of the Law of the Constitution. This was in 1885. Here, Dicey argued that Parliament, in theory, possesses absolute power to legislate on any subject, and as a result of which, this principle has remained a cornerstone of UK constitutional law ever since. There are a number of key characteristics of parliamentary sovereignty. The first is this idea of legislative supremacy. Parliament has ultimate authority to make laws on any issue. Now, one of the things that A.V. Dicey noted about this idea of parliamentary sovereignty is that there is a distinction to be made on the idea of sovereignty from a legal perspective and the idea of sovereignty from a political perspective. So he distinguishes between legal sovereignty and political sovereignty. In essence, legal sovereignty is the Parliament's ability to pass any laws. They have unlimited legal authority to do whatever they so choose. But politically, there are obviously constraints because of the fact that Parliament is accountable to the people. Parliament is elected through elections over the course of every 5 or so years, or even shorter if you're talking about the last sort of few elections that have taken place. And so as a result of that particular fact, Parliament could not politically pass any law they so choose, because politically they have to be accountable to the people. If they passed a law that was particularly unpopular, then they would be in trouble at the ballot box by the next election because we would vote them out. And so while Parliament could legally do whatever it wanted, even do things that are deeply unpopular with the electorate, there is still political constraints that are associated with the passing of legislation. Unlike countries with written constitutions, like that of the United States, or should I say more specifically, unlike countries with codified constitutions, I always like to make a distinction when I teach constitutional law on the Law Academy between the idea of written and unwritten versus codified and uncodified. The UK Constitution, the vast majority of it is in fact written. It is written down. Parliamentary statutes are written down. Judges' opinions in the common law are written down. Even a lot of conventions are written down here and there. The point isn't that they are not written. The point about the UK Constitution is that they are not all written down in one place. They're not all written down in a single document that we call the Constitution. This is unlike the United States, in which they do have a codified constitution, where it is all written down in one place. There's one single document, you've got your constitution, and you've got your 27 amendments that form part of the United States' constitutional framework, and you can hold it in your hand, and that is all the constitution is. And so unlike the countries with codified constitutions, the UK constitution is uncodified. And so while there are norms, conventions, and principles, there is no overarching legal document that restricts the scope of Parliament's legislative power. And then finally, in terms of characteristics here, something that we've touched upon previously, is, again, contrast to systems such as that of the United States, which can annul laws that are found to be unconstitutional. If Congress, for example, the US legislative branch, decides to pass a law that is unconstitutional, the US Supreme Court, through its process of judicial review, as established by the case of Marbury v. Madison, will undermine and declare that piece of law to be unconstitutional. The UK courts cannot, by contrast, question or set aside acts of parliament in this way. They can question administrative decisions, they can question parts of the executive branch and the way the executive branch works, so the government, but they cannot do the same for parliament. It does not extend to acts of parliament, and this maintains the supremacy of parliament over the courts and the judiciary. So with all this being said, there are traditionally a number of different ways in which people have sought to argue that parliamentary sovereignty has been challenged over the years. There are a few arguments here that are presented, but I would argue that none of these are actually challenges to the legal concept of parliamentary sovereignty. And I'll explain why as we get to each of them. And they all basically follow the same formula, okay? And ultimately, every one of these so-called challenges are still made, and they are still represented by parliamentary legislation. I'll explain what I mean as we go on. So, prior to the Brexit referendum, some people argued that the European Union and EU law was something that undermined the principle of parliamentary sovereignty, owing to the supremacy of EU law over the law of the member states, in cases like Costa and ENEL and the Van Gendeloo's case, as well as the fact that there is the principle of direct effect, in which the European Union, certain European Union laws, is directly effective and directly applicable into the legal systems of member states. All of this seems to suggest that the law of the European Union prior to us leaving the European Union, prior to Brexit, was supreme, or at least undermined the basic doctrine of parliamentary sovereignty. Well, one of the things that needs to be noted with the issuance of EU law and the previous membership of the European Union is that it was authorised under the European Communities Act of 1972. The European Communities Act was an act of parliament, and so acts of parliament such as the European Communities Act indeed made it very, very clear that EU has permission to pass laws that essentially could undermine or potentially overrule different principles of domestic legislation. But it is the law of Parliament that is essentially giving the European Union that authority. That is how it is seen that you can have parliamentary sovereignty and membership to the European Union. Now, there are various cases that potentially challenge this interpretation, specifically challenging the doctrine of implied repeal. The factor-tame cases, for example, make a point of where minor parts of particular fishing legislation have deep impacts in terms of being contradictory to the European Communities Act, and despite the fact that they are passed after the European Communities Act, the doctrine of implied repeal didn't seem to apply in those circumstances. Now, the counter-argument to that is that the doctrine of implied repeal is just an extension of the basic principle of parliamentary sovereignty. It is not at its heart parliamentary sovereignty in and of itself. So the idea that Parliament is sovereign to make and unmake any law they so choose is one principle, and the implied repeal doctrine is just an addition to that principle. And nobody necessarily says that implied repeal is, if you don't have implied repeal in every circumstance, then you don't have parliamentary sovereignty. That is the sort of counter-argument to that claim. But all of this is obviously moot in terms of points because, of course, since the 2016 Brexit referendum and the European Withdrawal Act of 2018, the UK has formally left the European Union. This took place in 2020, and we formally left the single market towards the end of 2020 as well. What about the Human Rights Act? Well, all the Human Rights Act does is incorporate the basic provisions of the European Convention on Human Rights, the ECHR, into UK domestic law. Now, the Human Rights Act does not technically limit parliamentary sovereignty, but it does nevertheless seemingly present present requirements onto Parliament to consider the compatibility of its legislation with the Convention rights. So, for example, under Article 4 of the Human Rights Act, the courts are able to, if there is a clear contradiction between a piece of parliamentary legislation and the Human Rights Act, the courts are able to issue what is known as a declaration of incompatibility. And this is a declaration to basically make it very clear and to signal to Parliament that there is an incompatibility, there's a contradiction here. One of the convention rights in the Human Rights Act is being violated by the existence of this piece of legislation, or by the existence of this provision within this piece of legislation. Now, this might seem like an undermining of parliamentary sovereignty until you realise that declarations of incompatibility are merely signals by the court. They're merely statements by the court. They are not requirements that Parliament has to then take up and go about their business reforming the law. When the courts, for example, do issue a declaration of incompatibility, and subsequently Parliament does amend and change the law in that process, that is not because they are legally bound to do so. That is because they are constrained politically, because they want to be seen to essentially be acting in accordance with the Human Rights Act. So this declaration does not invalidate law, and Parliament remains free to amend or repeal the law. Parliament also remains free to completely ignore the Human Rights Act. They could repeal the Human Rights Act. They could repeal it and replace it, or they could just repeal it and not replace it and just leave us in a state of no human rights. All of these things are perfectly valid principles within parliamentary sovereignty. What about the concept of devolution? Well, the process of devolution has introduced certain limitations, at least theoretically, on the idea of parliamentary sovereignty, particularly concerning the legislative powers of the devolved administrations of Scotland, Wales, and Northern Ireland, and also the City of London. Now, these regions have their own parliaments or their own assemblies, and these parliaments or assemblies have specific powers in areas such as education policy, health policy, or transportation. And although it is the case that Parliament remains sovereign and retains the ability to legislate on devolved matters, in fact, devolution is established by reference to the fact that it is done through parliamentary legislation. The only reason why devolution in Scotland happened is because of the Scotland Act. The only reason why devolution in Wales happened is because of the Government of Wales Act. Now, even though that is the case, it is still nevertheless bound by something known as the Sewell Convention, which dictates that Parliament will not legislate on devolved matters without the consent of the relevant devolved body. So again, another constraint on Parliament and parliamentary sovereignty. However, the counter-argument of that is that the Sewell Convention, being a constitutional convention that it is not legally binding. It represents a political commitment that has effectively limited Parliament's legislative power, but not Parliament's legal sovereignty, its political sovereignty. Think back to the distinction between legal and political sovereignty that I noted that was cited by A.V. Dicey. You also have constitutional conventions. Again, not legally enforceable, so just instantly keep that in the back of your mind. These are not legally enforceable, and so the only limitation that can be seen here would be political sovereignty. But nevertheless, constitutional conventions and parliamentary practices can limit how Parliament exercises its powers from a political perspective. These essentially are informal rules and expectations that guide the functioning of Parliament and its relationship with the other branches of government. And they also shape how sovereign power in Parliament is able to be wielded. But and ultimately, the practice that we see of Parliament is that they are often reluctant to try and override constitutional norms or to legislate in a matter that would undermine principles that are established by democracy and democratic ideals. Judicial oversight, again, while courts in the UK cannot strike down acts of Parliament, they can still play a significant role when it comes to interpreting legislation. And so this can have the effect of being somewhat undermining in terms of its application to parliamentary sovereignty. Courts apply, for example, the principle of judicial review when interpreting law, ensuring that laws are applied consistently with basic principles of justice and fairness. Courts can also issue rulings that impact the way Parliament legislates, especially when it comes to laws in a way that protects fundamental freedoms or even tries to resolve conflicts with international law. But again, just remember that, as we've noted, that Parliament is not limited directly and legally by the concept of judicial review. Judicial review does not extend to being able to strike down or to challenge directly and legally the implications of a parliamentary statute. And then finally, what we've mentioned and we've been continuing to mention throughout this lesson is, of course, the idea of public opinion, the distinction that A.V. Dicey makes between legal sovereignty and political sovereignty. In practical sense, then, Parliament's sovereignty is constrained by its public opinion, by the political process, and by the actions of various different members of civil society. Laws that are seen as grossly unpopular or undemocratic may be challenged or even lead to political pressure that would promote Parliament to amend or to repeal them. If they do not, then they would get a hammering at the ballot box, and often these people would get elected out of office, which is something that they don't want to do, and so as a result of which they are constrained by that. But again, this is only it's only a political constraint. It is not a legal constraint. Parliament could legally do whatever they want, regardless of public opinion, but they are constrained politically because of the fact that they are accountable politically. They are accountable to the people. And so that summarizes this final lesson on the subject of parliamentary sovereignty. It remains a cornerstone of the UK's constitutional system, and it asserts parliamentary supremacy when it comes to making laws. It is not absolute in the sense that it is politically limited, but in the legal sense it absolutely is, and that there are traditional challenges to the concept of parliamentary sovereignty, including the Human Rights Act, the EU devolution, and other issues such as constitutional conventions.